Hi, I'm Tom Roberts with the Virginia Civil Rights Law Firm of Thomas H. Roberts and Associates, P.C.
Hello, my name is Andrew Boda, also with the firm.
We have been providing representation for over 25 years to citizens of Virginia in constitutional and other civil rights matters.
We often get phone calls from clients who have faced charges of obstruction of justice. This is often the preferred charges of officers who are confronted by citizens exercising First Amendment rights or other constitutional rights. The law is actually very favorable to the client. Well, under the general obstruction of justice charge, rather than the other sections dealing with threats or force, it's necessary that the officer show that you actually impeded him in his performance of duties. It's not simply enough to speak to him or to engage him in conversation during the course of his duties. You actually have to affirmatively impede him. And normally this requires direct action and by forcible or threatened means.
The Virginia Supreme Court has already spoken in the case of Love versus Commonwealth. It said, to constitute obstruction of an officer in the performance of his duties, there must be acts clearly indicating an intention on the part of the accused to prevent the officer from performing his duties. Obstruct ordinarily implies opposition or resistance by direct action and forcible or threatened means. The Commonwealth has to prove that.
So there have been courts that have made it very clear that engaging the officer in a dialogue, even if it's somewhat hostile or even if it's antagonistic, is not necessarily obstruction of justice.
The Virginia Court of Appeals in Ford versus City of Newport News already emphasized that the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Speech is often provocative and challenging, but it is nevertheless protected against censorship or punishment unless shown likely to produce a clear and present danger of serious substantial evil that rises far above public inconvenience, annoyance, or unrest. The Virginia Constitution is one of the masterpieces on freedom of speech, and it states in pertinent part, the freedoms of speech and of the press are among the great bulwarks of liberty and can never be restrained except by despotic governments. Our firm is committed to preserving and protecting your right as a citizen to speak on matters of public concern without fear of being arrested. The U.S. Supreme Court, in the case of City of Houston versus Hill, stated the freedom of individuals verbally to oppose or challenge police actions without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. Our law firm is committed to holding back the growing police state that we face. Again, the Virginia Supreme Court spoke in Ruckman versus Commonwealth. There the court said, as the Supreme Court has held, and as the plain language of the statute states, obstruction of justice does not occur when a person fails to cooperate fully with an officer, or when the person's conduct merely renders the officer's task more difficult, but does not impede or prevent the officer from performing that task.
Representing clients who have been improperly charged with obstruction of justice gives this firm the opportunity to delve into the constitutional protections, both state and federal constitutional protections, to delve into the case law that has been developed in the defense of the citizens' rights, and to put together a solid defense, or in the civil context, a solid action that allows us to further protect and defend those constitutional rights, going back to the foundation of this country and this Commonwealth. It's necessary to have experienced counsel in cases like this, because first of all, the experienced counsel knows the law that will greatly assist in developing both the claims and any responses to the other side's defenses to this action. Additionally, it's important to have experienced counsel in order to ensure that the proper evidence is collected in a timely and efficient manner so as to best preserve your claim. And furthermore, it's important to have effective and efficient counsel in order to ensure that the tactics that we use at trial are the ones that are going to best persuade the jury to enter a verdict in your favor.
If you have been improperly charged with obstruction or a similar offense where there is no probable cause, where your speech was the motivating force for the government to pursue you, then we're interested in hearing your story to decide whether this firm would be able to represent you.